Hello, my name is Calrie Marsh and I practice in the area of bar admission. Today I want to talk about the benefits of hiring an attorney to help you navigate the bar application process. Included in that is what type of applicants should or are highly recommended to hire the assistance of counsel. The first group of applicants are older students. Applicants who have lived a full life, who may be pursuing law as a second or third career, who have a lengthy history, and not necessarily negative history, but just a lot of information. These applicants are required to go back 20, 30, 40, or even sometimes 50 years to provide information in response to the questions on the bar application. This may be tough for them to navigate, and I recommend that they seek the advice of counsel, in particular someone who's going to walk them through the bar application process, ensuring that all of this information is gathered prior to submitting the bar application and that the application is complete. Another group of applicants who may require the assistance of counsel to help them with their bar application are those with recent and or severe criminal history. This is a very slippery area because the board sees these events, these actions, these charges, convictions as a red flag and a potential reason for disqualification. Therefore, the applicant is served best by having these items explained fully, having the documents to support these items, and to ensure that the board is able to communicate with the applicant through counsel in order to get to the bottom of the issues. And when presented properly, these issues may still require further investigation, but the bar application sets the tone for the way the application process will proceed. Another group of applicants are those who have mental health, drug addiction, alcohol addiction issues. And this is because there is a lot of documentation that's required. If you've had treatment, you may be required to provide treatment records. If you've had diagnoses, you may need to provide treatment provider information, and the board may request records from that treatment provider. And you may have to provide evidence that this issue does not impair your ability to practice law. Therefore, an attorney would be instrumental in helping you navigating through this process, helping you gather these documents, being a liaison between the board and your medical providers, and help to smooth the process of getting this information to the board and allowing the board to accurately and adequately assess your character and fitness. Another set of applicants who may need the assistance of counsel are those with financial history issues, meaning you have a history of debt, delinquency, tax issues, allegations of financial fraud, you have judgments and liens that are outstanding, or you've shown a pattern of financial irresponsibility over the past 5 years, you filed bankruptcy, and anything that touches on your financial responsibility. If it's lengthy, if it's severe, if it's recent, you may need the guidance and the assistance of counsel to help you present this information to the board, as well as present evidence of rehabilitation from this conduct to the board. Another group of applicants who may need assistance of counsel are those who have educational discipline, whether it's academic discipline or misconduct discipline at the undergraduate level or graduate school level, simply because you need those records. You need to accurately disclose to the board what happened, how it was resolved, and your memory may not serve you well if you're trying to recount these incidents. And so a good attorney will help you to get these records, present this information to the board, and have the board be able to assess your present character and whether you have rehabilitated from this conduct and you are eligible for admission. Now, you may have one or more of these issues, and the more of these issues you have in combination, the more highly I recommend that you seek the advice of counsel in assisting you in navigating the bar application process. If you have one or more of these issues, you may have to go before the board for an investigative hearing. An investigative hearing is an informal hearing where the board wants to see you, meet you in person or via Zoom, and look you in the eye, making sure that what you've presented on your bar application is credible, that you're credible, that everything is consistent and corroborated, and that they can trust that you have rehabilitated from your past actions and you are eligible to move forward and become a member of the bar. If all goes well with the investigative hearing, you may be granted clearance for admission to the bar. Now, if you are not granted clearance at the investigative hearing level, then you will move for the next level, which is a formal hearing. A formal hearing can best be described as an administrative trial. And this is a intense process, and you are a law student, not a lawyer, and you're not in the best position to represent your interests at a formal hearing. This would be the time to hire an attorney to help you to navigate through the formal hearing process, presenting evidence that you have rehabilitated from this conduct, presenting evidence in defense or that's exculpatory for this conduct. And it's your burden to show by clear and convincing evidence that this past conduct is not disqualifying. And a qualified attorney can help you with this process, being the interface between you and the prosecutor for the board, which is the Office of General Counsel. You may not have many or any of these issues, but simply want to reduce the stress and pressure of completing and submitting your bar application. An attorney can be the bridge between you and the Board of Bar Examiners. An attorney can be the catalyst for reducing stress under the circumstances. So you may choose to hire an attorney simply to reduce the stress of the bar application process. Regardless of your reason to hire an attorney, you should consider carefully this choice and this process, and you should do some investigation of your own background and decide whether an attorney is required or not. There are some issues that the Florida Supreme Court has made clear will result in a denial of admission. These include felony drug trafficking convictions, for example, the case of the Florida Board of Bar Examiners versus Castro, and where you have a professional license which has been revoked permanently or has been revoked without the potential for reinstatement. For example, if you are a doctor or an accountant or another professional whose license has been revoked for misconduct and you will never have the opportunity to reinstate that license, the Supreme Court has made it clear that you are not a candidate for admission to Florida Bar and that you should not apply. And so there are some instances where an attorney will not help you navigate through the bar application process because the Supreme Court has said we will not admit you if you apply. Overall, most applicants are admitted to the Florida Bar. It may take them a while to achieve that. Some applicants may be delayed. But if you start from scratch, meaning you start with the basics, the bar application, you are increasing your chances of being admitted and being admitted in a timely fashion. If you find this video helpful, please like, subscribe, and share. Until next time, I am Calrie Marsh, Bar Admission Attorney.